We're watching history unfold right now at the Supreme Court, which heard arguments about putting a president on trial today. Historic, unprecedented. All the words are true about this one. No other president has been indicted like this. DOJ Special Counsel Jack Smith memorably charging Trump for the failed coup and the plots leading up to Jan 6. Trump's lawyers arguing he should be immune, basically totally immune, because he was president during those efforts. Now, that is a new, relatively made-up claim, which they lost unanimously before the respected D.C. Court of Appeals. You should keep that in mind, because that is the recent precedent and context for today. And you may remember that was the now infamous hearing where the Trump lawyer openly claimed that as president, Trump could have a license to kill American opponents. And that was the kind of chilling talk that many, many people across the spectrum rebuked then. That kind of talk was back today, with grave questions about murder and coups, and Trump's lawyers saying it's okay or it all depends.
Let's say this president who ordered the military to stage a coup
orders the military or orders someone to assassinate him. Is that within his official acts?
I think it would depend on the circumstances. It would depend on the hypothetical.
The case raises issues that go far beyond just a special counsel case.
One might argue that it isn't plausibly legal to order SEAL Team 6, yet the president uses it in an absolutely outrageous manner.
The court has to make decisions not just applying to President Trump, but also decisions that will apply to future presidents.
A president is entitled for total personal gain to use the trappings of his office without facing criminal liability.
His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder.
Here's what that means in plain English. I, Donald Trump, can do anything I want.
There's nothing to suggest that presidents need immunity because they've managed to do just fine for over 200 years.
Those are just some of the high points today. The Constitution does not say ex-presidents have immunity. Never has. Before Trump, no one even claimed that. After Trump, the courts now are full of prosecutions of his supporters and his aides. More indictments came just last night. And this is the obvious fact here. The insurrection was a public crime spree. It was televised. It was live streamed by some of its participants. And now many of them are sitting in prison or awaiting trial. And those related election plots have been busted just the same. But many justices today seemed almost oblivious to that current reality and threat. Today was a historic day for the Supreme Court in the sense that we will be reading about this in history books. But I got to tell you off top tonight, I'm going to show you why and give you the breakdown. Today was also a depressing day at this Supreme Court, as its Trump appointees and some other members seemed oblivious to this reality of this insurrection era, oblivious to the DOJ's victorious sedition convictions, which not everyone may follow, but judges and Supreme Court justices are supposed to track that. Those people who stormed the Capitol got their day in court, and many of them were convicted by juries of their peers. Other justices, though, did press Trump's lawyer on how the U.S. is supposed to deter or punish a coup or military coup if Trump's theory, if accepted, means a kind of total immunity.
Let's say this president who ordered the military to stage a coup, he's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act.
Official act there is a stand-in for them saying it's okay. It depends. Well, by definition, it's not okay. A military coup would be against the official governance of the nation. If you can do a coup, can you do murder? That was the infamous part of the lower court's hearing I reminded you about. Today, Obama appointee Justice Sotomayor pushed Trump's lawyer on that violent, grim, authoritarian logic.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
There you have it, out in the open, before the highest court in the land. The current Republican Party nominee's lawyer defends murder and the assassination of Americans and just slaps the word official on it. That's how you know they're defending it, when they say, oh, it's official act. And says that should be something that the president can do. License to kill, total immunity. So here we are. Don't say they didn't warn you. We are hearing some of the most extreme authoritarian arguments ever presented to the Supreme Court in the modern era. I guess you could score one for transparency and say they're being pretty clear and transparent about what they're defending in the past and what they would do in the future. That's the Trump defense. Inside the courtroom today, Prosecutor Jack Smith watched the veteran litigator that he picked and sent in for this pivotal case, probably the most pivotal case on presidential power since U.S. v. Nixon. And that lawyer, when it was his turn, took a 2x4 to this Trump defense that I've been telling you about, saying this made-up immunity, if you did it, would protect and therefore encourage murder, treason, sedition. And again, sedition is, of course, what those Jan 6 attackers were convicted of.
His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution.
That's true. The justices know if they say there's an immunity here, it will be a new thing, not an originalist thing from the original understanding of the Constitution, not a textualist thing from inside the text of the Constitution. I mentioned those are the prisms that many conservatives say they use on the court, except for apparently when they don't. There was no immunity under the law for Nixon. He took a pardon to avoid indictment, a basic sort of high school history class point against Trump that many people have thought about. Justice Jackson raised it very bluntly, and you'll be able to listen here, while other justices also appeared to root for Trump and reveal their leanings by musing about their opinion that pardoning Nixon may have turned out to be a good thing. And remember, your personal opinion about a thing that a president could do. Ford chose to pardon Nixon. He could have not pardoned Nixon. That opinion is not supposed to be how this court resolves the narrow legal question of whether the Constitution prevents DOJ from putting Trump on trial or not.
What was up with the pardon for President Nixon?
I think
if everybody thought that presidents couldn't be prosecuted, then what was that about?
We said, gosh, Nixon versus Fitzgerald. That's something courts shouldn't get engaged in because presidents have all manner of motives.
President Ford's pardon, very controversial in the moment.
Yes.
Now looked upon as one of the better decisions in presidential history.
Won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves?
The last question is pretty cynical. Alito saying, if you allowed presidents to pardon themselves, wouldn't they all do it? Pardons are for criminals. No president has tried to pardon themselves, not even defended Trump. So it is odd for a sitting justice to ask if that would be the norm. Odd is a diplomatic word. It also sounds like yoga-level backbending to find some way to get Trump off the hook again. Now, the court's Republican-appointed majority was clearly warmer to Trump's arguments than those lower courts, which unanimously rejected them on a bipartisan basis. Critics say that shows the more obvious partisanship in this MAGA court overseen by Justice Roberts, who appears unable or unwilling to curb this red partisanship. But that does not mean that there were no good arguments for the legal claim of some kind of immunity, a limited presidential immunity. And I want you to understand the key points today. It was 2.5 hours, so we're not playing all of it. But I will show you one of the strongest arguments for that side came from a question also by Justice Alito. He asked if a president's bad ideas and official acts can be prosecuted, right? That's what Jack Smith is saying, that it should be able to be part of the case. He asked, then what about wartime acts like President Roosevelt, interning, innocent Japanese Americans, an operation that was first, at the time, deemed lawful. That's important for context. They were fighting the Nazis, they were fighting the Japanese, everything was on the line. But later, it was found to be unlawful by the Supreme Court itself, and as the war tempers cooled over the decades, it's widely viewed in civilized society as a racist and grave injustice. So Alito asked, given that history, wouldn't the door be open to prosecuting FDR or virtually any president for such official acts?
President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II, couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes. President Roosevelt made that decision with the advice of his Attorney General. That's a layer of
safeguard. Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
Lawyers love to nerd out. Of course, the point's not what the AG said at the time or what Hoover said. The point is not whether it was signed off, but whether there is some outer limit, however far, on prosecuting a president for those official acts, which might have been taken in wartime good faith at one moment and later look like a war crime or a civil rights violation. That's a good question. Now, the Jack Smith rebuttal is, this ain't World War II. And Donald Trump's efforts were not on behalf of the U.S., not even a good faith but mistaken effort at national security. They were against the U.S. and its lawful election and its president-elect and his incoming administration at the time. Big difference. Now, one of the lowest moments today also came from Justice Alito, who asked a question suggesting that maybe America should just appease coup leaders. Don't upset them. Because if you do, or they're worried about being prosecuted for actual crimes, they might try to stay in power, stage a coup, end democracy. Bonkers. But I'm going to play for you the extreme premise of this question, where Justice Alito asks if a president worried about prosecution might be more likely to cling to power illegally. He says a stable democratic society requires a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent. Let's take a listen.
If an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy?
No, it will not. Justice Alito is very intelligent, so based on my observation, I think it's more likely that he is trying to float this wild idea rather than really embracing it. Because to embrace the premise of that question, and they ask all kinds of questions, but the premise of that question is, gosh, we better be really afraid of people who might cling to power if they don't like being held accountable after they leave office after losing a lawful election, so let's not go down this road. It's called appeasement. It's dangerous when you do it to enemies, foreign or domestic. Why Justice Alito is using his perch on the Supreme Court to raise that today, only he can answer. But it is literally the opposite of the oath judges take to talk like that. Now, where is the court headed? I just went through a lot of the key points from this argument. The Supreme Court's conservative majority does seem poised to narrow the scope of the whole criminal case against Trump. That's how the New York Times viewed it today, reporting on what happened, and basically make it hard to conduct the trial before the 24 election. They also note that Trump's lawyer pressed an extreme version of the former president's argument, claiming presidential orders to murder political rivals or stage a coup could well be immune from prosecution. I quote that just to give you a sense of how this is playing. This is where we are in America right now. We are just almost normalized or casually discussing the talk of murder and coups. And there are many places in the world in history and right now, fewer in Russia, where that's just part of life. And you go on, you try to soldier through life knowing that Putin does murder Russians. That's what he does. But is that where we want to be here? Delays alone will give Trump most of what he wanted out of this case because he can punt this past the election year. And based on what the court said on the bench today, looks like he's going to get at least that, based on what they said. But before we bring in our guest tonight, I'm going a little longer than usual. I hope that's okay with you. I do want to put this in the wider framework of the problems we're facing. Because today is legally a dark day for this Supreme Court in what the justices didn't say and didn't deal with and didn't focus on. Very little of today's arguments dealt directly with the horrific insurrection at the center of this case, which is the DOJ, Special Counsel Jack Smith's case against defendant Trump, which relates to a now convicted sedition. And so the longer you listen to these arguments today, the more you kind of got turned around away from this case and this reality. For all the hypotheticals about the future or what would happen with future presidents and all the history about presidents not named defendant Trump, the justices didn't focus much on the core reason there is a first ever federal prosecution of a president. He's the first one to try to steal an election and stop the peaceful transfer of power. You know this because he did it in public. He is legally presumed innocent. He deserves a trial. He might beat the trial. That's how we do it here under the rule of law. But that's how we got here. Not with hypotheticals about chilling a presidential act, not with wartime overreach done perhaps on behalf of the United States, however wrongly. Not a president in the middle of their term trying to govern, but a defeated president awaiting a president-elect. And for the first time in our history, don't forget it, violently stopping the peaceful transition of power with a sedition that's now been convicted. Now, that's some facts that I've put together for you, but I'm also going to quote from a longtime Republican, Judge Luttig. You may recall he testified on these very issues before Congress, and he had a tie to it in urging following the Constitution when he was dealing with then outgoing Vice President Pence. He observes how the court largely avoided these points I'm mentioning today, with arguments that discussed everything but the specific question presented. If a former president may be prosecuted for attempting to remain in power, notwithstanding the election of his successor by the American people, and thus depriving his lawfully elected successor of the powers of the presidency and preventing the peaceful transfer of power for the first time in American history. True. And while the court spent hours, I mean literally hours, pondering how a coup might involve official acts, Luttig notes that and he knows it too, I should say, but he notes, and he wrote this today, that attacking Congress is not part of the president's job, to which we say, duh, and also sad that we have to do this kind of constitutional math. But he wrote, it is not a core power or function of the president to ensure the proper certification of the next president, the one in this case who beat him, President-elect Biden, by the Congress. That core point is not very complicated. Let me say it in English as I round out my reporting on today's case. Breaking the law is not enforcing it. Stealing elections is not protecting them. Committing voter fraud and elector fraud is not election integrity. Duh, again. Now, someday, there could be a tough case where the court does weigh potential prosecutorial overreach against the president who was just doing their job or prosecuting a difficult war with second guessing afterward. But no disinterested expert seriously thinks that's the case here. Today, some conservative justices claim they have to step in, though, because there needs to be a rule for the future. Not about defendant Trump, they said, but for the future, later hypothetical cases. That's what they got to do. Well, as a longtime court watcher, I call bull. There's never been an insurrection like this before. The legal task at hand is how to prosecute it. Not to anxiously, neurotically cogitate about preventing a potential later overreach. This isn't an overreach, but someday they might be one. And so rather than dealing with this sedition, let's worry about this future overreach. And, oh, the people worried about it are the people appointed by, oh, the guy who benefited from this failed sedition. And then they keep insisting on the bench today, some of the Trump appointees, this isn't about him. They're bad at PR. When you say this isn't about the money, it sounds like it's about the money. And when you say this isn't about the guy who appointed me and our alliance and that we might help him get out of his jam and he might become president again so we can get more Trump appointees on the court, well, you sound pretty guilty in your mind. Now, if there is a later case, this is the kind of court that would probably take that case anyway, so they wouldn't even be stuck with some old rule, like okay to the coup prosecution, but the next one is out of bounds. And they say, oh, but we already made this ruling. Does anyone really think they're sitting out future big presidential cases? They'll say what they said in this case and the Trump ballot case. They take the case, sometimes they take it right in the middle of everything and say it's too important for them not to weigh in. And then, finally, I'm just disentangling their logic, just tonight, since they made these points today. Would they then be bound by this case? Again, if they said, okay for the coup prosecution, but we're worried about a later overreach, oh, we're bound by the earlier, narrower version of the thing we said. Would they be bound by this? Who knows? They certainly did not feel bound by Roe v. Wade. And they testified under oath they would uphold that precedent. So, forgive me for going on for some time. The arguments were longer than usual, approaching 3 hours. And while I mentioned there were some decent points made, some tricky questions, at the core, what we saw today was, best we could tell, many members of the Supreme Court shutting their eyes to the insurrection we lived through. Yes, Lady Justice is blindfolded. But the justices, we got a lot going on set, but everything's fine. Lady Justice is supposed to be blindfolded, but the justices are supposed to see the facts. And if you can't see the facts in front of you about this MAGA insurrection era, how can we possibly rely on you to prevent the future coups that we're told are being planned?